Picture this. You're a DC couple in an open marriage or a polyamorous relationship. You're starting to plan your wedding, and you suddenly realize a standard prenup template is simply not going to cover your situation. The specific worry here is clear. You aren't sure what a court will actually enforce if your relationship structure involves outside partners, and you absolutely do not want to sign something that falls apart the moment a judge reads it. Here is exactly what a DC prenuptial agreement can and cannot legally protect for couples practicing ethical non-monogamy. When tackling this topic, there are 6 specific questions that we constantly see. 1. Can our prenup actually address our relationship structure, or will a DC court just throw that part out? 2. If marital money gets spent on someone outside the marriage, can that come back to hurt us financially in a divorce? 3. Are rules about notifying each other or approving partners something a judge will enforce? 4. Does being in an open marriage or polyamorous relationship put custody of our kids at risk? 5. What should we actually put in writing to protect our finances around outside relationships? And 6. How far ahead of the wedding do we need to get this signed so it holds up later?
To answer these, we have a clear roadmap. First, the statutory framework. Second, finances and behavior. Third, custody and children. And finally, execution timelines.
Let's start with a statutory framework, grounding the law right here in DC.
The legal anchor for all of this is the precise statutory text. Under DC Code Section 46-503A8, a premarital agreement is allowed to cover any other matter, and that explicitly includes personal rights and obligations, provided they don't violate public policy. This catch-all provision means a couple can legally include a clause documenting mutual consent to their specific relationship structure. It takes the arrangement out of the shadows and places it directly into an enforceable contract. Now let's move on to finances and behavior and look at how this law actually applies in practice. DC is a no-fault, equitable distribution state. Practically, this means a judge divides property based on fairness rather than an automatic 50-50 split, giving the court very broad discretion. Because judges have this broad discretion, spending marital funds on outside partners can become a major legal liability if it isn't legally documented ahead of time.
Here is the core difference. Without a prenup, spending marital funds on an outside partner can easily be challenged in court as dissipation of those funds. Basically, that means one spouse argues the other wrongfully wasted marital assets. But with a properly drafted agreement, you establish financial boundaries for outside relationships in advance. By defining those exact parameters on paper, you effectively neutralize that dissipation argument before it can ever be raised. If you want the full breakdown of which specific clauses to include for property, housing, and financial boundaries around outside relationships, the full article is linked in the first comment below. Continuing with what actually holds up in court, we really have to distinguish between behavior and finances. Fidelity clauses or behavioral rules, like requiring partner approval or mandatory notification, generally will not hold up in DC courts. Judges simply do not want to police domestic lifestyle rules. However, clauses setting strict financial limits on how marital money gets spent on outside relationships are highly enforceable. So the court won't enforce your schedule, but they absolutely will enforce your financial boundaries. Next up, custody and children. Let's look at the hard legal limits.
No DC prenup can decide child custody or waive child support in advance.
It is a definitive legal boundary that no contract can predetermine custody arrangements for a minor. Now, with that being said, being in an ethically non-monogamous relationship does not, by itself, affect a parent's custody rights. DC courts strictly apply the best interests of the child standard. They are looking at stability, health, and adjustment. Because of this, maintaining a strong, well-documented parenting record showing deep involvement in schooling, healthcare, and daily care is critical. That evidentiary record is what protects your rights, not a clause in a prenuptial agreement. Let's turn to execution timelines, which is all about making the agreement binding.
30. That is the crucial number of days here. Family law attorneys strongly recommend finalizing and fully executing the agreement at least 30 days before the wedding date.
This 30-day recommendation is directly tied to the Burtoff standard. Established by a 1980 DC case, the Burtoff standard is the test courts use to determine if a prenup was signed voluntarily without undue pressure or duress. To meet this standard, and to ensure your agreement survives judicial scrutiny, the process requires drafting the initial agreement well in advance, then ensuring both parties have independent legal counsel review the document. Finally, executing the final signatures at least 30 days prior to the wedding. Rushing this timeline is honestly one of the easiest ways to have a validly drafted document thrown out. To recap, A DC prenup can powerfully protect your finances and formally document consent around your relationship structure, but it absolutely cannot create legal obligations toward a non-married partner or predetermined child custody. The full article breaks down exactly what DC law allows and what it doesn't for couples in open marriages and polyamorous relationships, including the specific clauses to ask your attorney about. It's linked in the first comment. If you want direct DC family law guidance without having to search for it every time, make sure to subscribe to the channel. As you structure your future, ask yourself, what happens to your assets when your relationship structure evolves, but your legal documents do not?